Lordship.
First.
Please, Your Lordship. Which I beg to pray for listing of a matter, Your Lordship. The matter, the judicial order that the matter should have been posted on 16/11/2022. That did not happen. The records have been called. The records have also arrived. The Lordship can kindly fix it as per Your Lordship's convenience. For final disposal, Your Lordship. Please.
Ninth.
I'm grateful, Your Lordship.
May I please, Your Lordship. Well, I beg to mention, this item may be come up for orders now, since long this case is pending. On 1st of March, madam.
1st of March. Okay.
Obliged.
Lordship, on behalf of the department, Lordship, I'd like to mention item number 3. Though I haven't found the counsel for the petitioners, the counsel for the respondent is here.
I'm appearing on behalf of.
I need 2 weeks time to file an affidavit, Lordship. We have some difficulty, Lordship, in getting the
Reach
instructions.
too much, my lord.
Let the matter reach
Which
Yes, sir,
SMT
yes.
because you
Because
can't adjourn the
petitioner has to
matter.
be accepted.
There's a notification. You have to give in one
Yes.
day advance to the
Yes,
other
yes.
the
side.
counsel. Yes, Lord.
That notification is, keep that in mind.
I may not, I will come from Portsmouth. So kindly
Right,
inform the
much.
Lordship.
May I please, Lordship? I beg to mention for listing one IA, my lord.
Yeah.
Tomorrow, my lord, because of my lord, on the last date of 28/2, my lord, for submission of the application. That department is going to fill up the PGD and PGT post without holding the date, my lord.
Why are you mentioning so late?
My lord,
Monday.
Monday, obliged.
May I please, Your Lordship, my lord? I beg to mention for listing in motion, my lord, on Monday, my lord. Monday, my lord.
May I please, Lordship? I beg to mention, my lord, 4-5 cases, my lord, in the next week and thereafter next week.
Not. next
Motion
week,
cases
then
are there, motion cases are there for the next week, my lord.
Next week.
In admission cases in the first week of March, my lord.
10th March.
May I please, Your Lordship? Lordship, this is a mention for a listing of a IA, my lord, for stock of some petitioner's name of a WBC, my lord, for tomorrow, my lord.
Tomorrow, Monday.
Obliged, my lord.
May I please, Your Lordship, I beg to mention for listing 2 read petition, Lordship, for admission.
13th March.
Obliged, Lordship.
May I please, your Lordship, I beg to mention for listing. Lordship, the matter was last listed on 30th January 2023. It's an humble request to the Honorable Court.
Yeah, 15th March.
For admission, Your Lordship, I pray for listing. Next week, Your Lordship, for Thursday,
Next week is all full now.
Thursday, Your Lordship, or Wednesday. Thursday.
First.
Obliged, Lordship. May I please, Your Lordship?
Yeah.
I beg to mention for listing of a writ petition, my lord, on Monday, my lord. There is an urgency, my lord. During the pendency of the writ petition, my lord, a fresh advertisement has been issued, my lord. Obliged, my lord.
Yes, please.
Please, Your Lordship, my lord, this matter relates to some consideration of condonation of age of the petitioner, my lord, for the purpose of getting submitting her application for appointment as state teacher. My lord, the
You make your
petitioner has,
application.
my lord, the petitioner has passed state examination. Your Lordship may kindly see Annexure A at page 13, my lord.
Yes.
Thereafter, there was an advertisement, Annexure C, page 15, my lord,
Yeah.
where this advertisement was, whereby the applications were invited from qualified TED teachers, my lord, for filling up of 1433 number of posts of my lord, UP schools, my lord. There is a clause 6, Your Lordship may kindly produce. A candidate must not be less than 18 years of age and not more than 40 years for unreserved category, 42 years for ex-servicemen, 43 years for OBC. The petitioner belongs to OBC, my lord. I have annexed the certificate also. And as on 1st January 2023, my lord. The petitioner completed 43 on 31st of December 2022, my lord, only one day, my lord. So, my lord, the petitioner submitted a representation at page 17, my lord, for condonation of her age, so that she can submit her application, my lord.
Who is the authority to condone
The
the?
SSA, Mission Director, SSA. Mission Director, SSA.
Mission director?
Mission Director. He will have to take a call on the representation if they want to condone it.
Then let her file a fresh representation.
He can file a fresh, all the another representation is already pending. Yes, yes, file it.
Why not you file a fresh representation?
Yes, I'll file a fresh representation. It may be considered so that I can submit my application. My lord, so far as my information, my lord, tomorrow is the last day for submitting application, my lord. Tomorrow, Kali, no?
No, advertisement of key class.
Petitioner phone kori jonale ratipor. But the date we change korbo.
Where is the advertisement?
Advertisement, page 15, my lord, annexes C. I have annexed only the extract, my lord. The complete, my lord, advertisement is with me, my lord.
It's up to 1st March.
What?
Close
First
9,
March.
close 9 of your
First March.
advertisement.
Oh, yes, my lord. Then she will file a fresh representation.
Not clear who has issued the advertisement.
It
Then annex a part of the.
last year, no, it complete. Okay. Directors.
What you will find, see, page number 15. Thereafter, the complete advertisement not been annexed. Now my friend has submitted it.
My lord, I have annexed only the extract and I have the
Extract,
complete
no.
one.
Complete is
showed
the
this
elementary
one.
education. The
Director.
Director Elementary Education Assam, highly para. Yes, connect the part, only the first page of the advertisement. It is not the SSA, it is the Director Elementary Education.
Who is the second part? Who issued this? Who
Yes,
issued this?
It is here, my
She
lord.
has
Your
not annexed
lordship
it.
may- your
He has a
lordship
copy
can-
now.
Your lordship may peruse, my lord.
Why do you file piecemeal?
Are we do? Okay, yeah.
First page I have annexed, my lord. These are second, third and fourth pages.
Director Elementary.
So it will be the director who.
She will have to, now the Lordship will turn to page number 17. Now the representation is with the Commissioner and Secretary Government of Assam. So she have to make a fresh representation to the Director.
Elementary.
Yes.
Elementary.
Lordship.
But a copy has been served, my lord.
Not the mission director.
Not the Mission Director. Advertised by the Director.
But MS SP Chowdhury and council for the teacher. Also heard. Who addressed for elementary? Mr.
PK Boramal.
PK Boral and the Standing Council Elementary Education for respondents 1, 2, 3,
1, 2, 3,
4.
4.
IPO for 5 and 6.
And Mr.
As for that.
S. Boral and the Standing Council SSA for respondents 5 and 6. The petitioner is a TET qualified teacher. Stop. The Director Elementary Education, Assam, issued an advertisement. What date is this advertisement?
Page 15, my lord.
Oh, date 9.
It is from the, it appeared in, it was published in newspaper dated 11/2/2023.
Which was published in the Jana Sanjuk, local newspaper, Jana Sanjuk, on 11/2/2023. Calling for qualified Assam calling for applications. qualified in Assam teacher eligibility test within bracket ATET oblique single teacher eligibility test within bracket CTET for filling out 1433 post of Assam teacher and science teacher of UP schools. Stop. In the said advertisement, clause 6 provides that a candidate must not be less than 18 years of age and not more than 40 years for unreserved category, comma, 42 years for ex-servicemen, comma, 43 years for OBC oblique MOBC, and 43 years for 45 years for SC oblique ST within bracket P oblique ST within bracket H, and 50 years for persons with disability within bracket PWT as on 1st January 2023. Stop. Petitioner is an OBC candidate and she completed 43 years of age on 31/12/2022. Stop. Thereby she being overaged for by 1 day. Made an application before the Commissioner and Secretary to the Government of Assam, Elementary Education Department, praying for continuation of her age, of her or his, her, of her age. Of what is this?
She made prayer for condonation for 1 year, my lord.
1 year, 1 day.
Actually, there was delay more. She was only 1 day more, my lord. But she
continuation
prayed
of her
for
age.
1 year condonation. But
To enable her to apply for the post. Stop. As the said application is yet to be considered, and as the last date for filling up of applications online is 1st March 2023, petitioners before this court praying for direction to the respondents to condone her age. Stop. Considering the limited prayer involved in the petition, comma, considering the limited prayer involved, this writ petition is being disposed of in the motion stage, comma, and on consensus, comma, directing the petitioner to file a fresh representation before the Director Elementary Education, Assam, within a period of 2 days from today. Thereafter, the Director Elementary Education shall, today is what date?
this 23rd.
Shall dispose of the representation for condonation of her age, for condonation of the petitioner's age on or before 29th,
28.
28. No, 28 will be too late.
25 and 26 are
on or before 28th of February 2023. No, with the opposite observations and actions.
This case for implement has been tagged to date. It will be taken up first. 448.
48.
Yes, sir.
This is for impletement as
As respondent number, my lord, the
7.
seven. My lord.
Priya. You have
What?
any objection?
My lord, he is a necessary party, my lord. Admitted him.
Mr. A.K. Purkai.
B. Purkai.
B. Purkai. Let us count. For the applicant. Stop. Also heard Mr. Yeah,
Mal.
Council. Appearing for the
Writ petitioner, my lord.
respond opposite parties 6 and 7.
My lord. Only I am
Only
for
7, my lord.
7, my lord.
Opposite party number 7. Obligate petitioner. Anybody elementary? Mr. D.K. Boyle, understanding council. Elementary education for the opposite parties 1, 2, 3. APSC. You good sir? D. Gobert, standing council APSC. MS D. Barman, learned government advocate for respond number 5. And number 6.
I am for 6, my lord.
Okay, Bora for response 3. And Mr.
HK does, my lord.
HK Das.
Respond number 6.
For the respond number 6. Voilà. By this application, the applicant is praying for implementation. As party respondent number
7, my lord.
cannot be 7.
Oh. It's only, my lord. 6, 7, no.
7.
Because, my lord, in the writ petition, there are already 6
Respondents are there.
there, my lord.
From where 7 respondents have come in the IA.
Construction to follow, sir.
Because the petitioner included, my lord, that's why.
You have included yourself.
In the page number 3, my
Then,
lord.
Das, you are praying for?
Respond number 6, my lord.
6.
In the IA.
No. Respond number 6 is a writ petitioner, isn't it?
No, he is
Is
the
respond number
applicant.
7.
The respond number 6 is the applicant in IA 164, my lord, which is filed for praying for modification and vacation of the interim order.
Then you will be number 7, I think.
Yes.
My lord. My lord, in a plain reading of the writ petition, my lord, there are 6 parties are there. Now, my lord.
1 minute. I'm giving you this.
Yes, my lord, maybe get confused, my lord. At page 13 and 14, will make the scene clear, my lord, of my writ petition, my lord. Now, he want to
Petition
implement.
is WBC 55, isn't it?
Yes, my lord.
Yes.
If my lord may be pleased to peruse page 13 and 14. There are 6 respondents. Now, he want to implement as respondent number 7, my lord. That will clarify, my lord. Page 13 and 14 may kindly have a look.
Then you are this opposite party number 7.
My lord.
By this writ petition, the applicant is praying for implementation as party respondent number 7 in WBC number
55 of
55 of
2023.
on the ground that if any order is passed in the writ petition, it would have an effect on the
Mine.
applicant, and therefore he is a necessary party. The counsel for the opposite parties has no objections. This court has also perused the course shown in the deadline. Satisfied. Accordingly, the prayer for implementation is allowed. Stop. Then with petition, then I'll have to pass an order.
Yes, yes, my lord. If petition will be taken on merit, my lord, I will not file any affidavit. It's not required at this stage.
His implement is required. This IA is allowed now. He is required to be arrayed as a respondent. sir.
Formal order.
Some order has to be passed.
Yes, yes.
My lord, when my passing the final orders in this matter, my lord can pass an order at that time, including my lord, in that application. Formal order. That will do. My lord may hear the matter.
Okay, what is this?
My lord, the matter relates to, my lord, a transfer order is under challenge in the main writ petition. My lord. The impugn order, my lord, may be pleased to find the is at page 114, my lord. If my lord may recall, my lord, on the last occasion, my lord, when my respected senior friend has argued the IA, my lordship has taken a view that the entire writ petition is required to be adjudicated and disposed of.
Yeah.
So therefore, my lord, that order was also passed for filing an affidavit by the, my lord, Education Department, and Mr. U. Sharma took time till today to file an affidavit. But till date, my lord, I have not received any copy of the affidavit. So my lord may hear, my lord, without their affidavit also, my lord, I am ready to argue, my lord.
Sharma. You're in this case.
No, P. Sharma, my lord. P. Sharma took time, my lord. If my lord may be pleased to record the, peruse the last order, my lord.
PN Sharma.
My lord.
Here today, my lord. And we have received the instruction, man.
Can we proceed on the basis of your instruction?
It's up to your lordship, my lord.
It's not up to. See, there's some urgency involved in this writ petition.
My
That
lord.
is why we're taking up this writ petition
My
today.
lord.
If you want to file your affidavit, I'll give you 1 or 2 days.
My lord, Monday can be taken up. My lord.
We can take up.
Even, my lord, I am also in a, my lord,
Otherwise-
mode to dispose of, my lord.
One party is filing for vacation of the
My lord.
interim order. One party says, this court says, instead of vacating the interim order, we'll dispose of the writ petition. Now we cannot linger on like this.
My lord.
Based on our instruction, lordship may take up the matter.
Today,
Find that instruction, my lord will take on record.
it's up to you.
Boss.
My lord.
If you want to have your affidavit on record, that's a different thing.
Lordship may keep the instruction as part of the record, man.
Affidavit will help, my lord, sometime, my lord, if the matter required to go to the next
My
level.
lord, the issues that are there, my lord will decide subsequently. I am raising a preliminary objection, my lord. He is not a person aggrieved. He does not have any substantive right to that post. My lord, let him satisfy your lordship
Yes.
on that point, and thereafter, my lord will proceed with the matter. Because he is holding that post on an in-charge basis. His case is that is a promotional post and can be filled up by promotion only. No, it's a cadre post, and I have showed on the last occasion, my lord, that the post of senior lecturer, which he is holding, is filled up by promotion from lecturer. Lecturer, senior lecturer, principal. Now, my lord, from lecturer to senior lecturer, it's by promotion. My friend was promoted in college A. And thereafter, my lord, he was transferred to college B, where he is presently holding the post. Similarly, if that can be done, then, my lord, the same rule says from senior lecturer to principal, it's a promotional post. I am coming on transfer from I'm a regular principal. I am coming on transfer. How can he have any objection to that? What right of his has been infringed? Let him that be adjudicated. Mala, I think that will give the answer to everyone.
Yes,
I'm fully agree with my senior friend.
can you file your affidavit within 1 or 2 days? Then we'll take it up on Monday.
My lord.
Okay. Then in the main writ petition, right, in view of the order passed today in the main IA, in IA number 2, let's Dr. Jipindu Datta,
My lord.
comma, age 51 years, son of late Makhanlal Datta. You've seen the IA, the page 3. We implemented that party report number 7. Registry is directed to the as Mr. P. Burgayastan, and the council appears on behalf of the newly implemented respond number 7. No formal steps are required. Mr. I don't know him. With understanding council, elementary education shall file counter affidavit. Submits that he has received instructions and police for 2 days time to file counter. List the matter on. You want it on Monday or Tuesday?
Tuesday, my lord.
Tuesday, my
will
lord.
be better, my lord.
Tuesday.
The matter on 28.
My lord, affidavit may be filed by Monday, my lord, then I can have.
I'm saying within
Mal-
2 days.
mal.
You
Got you.
file-
Obliged, my lord. One xerox for these.
এইখানে May I please, madam? My lord, the matter pertains to Dixit of Mate. My lord, the excise standing council. Dixit group. He's here. My lord, the petitioner is working as a, my lord, he's a deputy superintendent of excise, my lord. He was first initially placed under suspension on 24/5/2017. Thereafter, my lord, a criminal case was registered against him, which led to his arrest, and he was behind the bars. That suspension continued, my lord. Then, my lord, he was granted bail. He approached before your lordship here, exhaling the suspension order. That suspension was set aside, my lord. During the pendency, when he was inside the jail, my lord, a show cause notice was issued to him. That show cause notice, naturally, he did not, that's reflected in the order of this honorable court also. After he was released on bail, the show cause is of, my lord, 18/8/2017. And he had received it on 12/2/2018. My lord, that my lord would find at page 43. My lord. My lord, this is the show cause notice issued to him, wherein it has been alleged that while he was holding the post of Deputy Superintendent of Excise during 2012 to 2015 at a warehouse, my lord, Guwahati, you have been found to be involved in defalcation of an amount of rupees so and so as excise revenue apart from sale tax, as per communication received from the dated 5/7/2017 received from the Deputy Superintendent of Police CID Guwahati, Assam. My lord, here my lord would find the list of documents were not given to him, but subsequently, my lord, the list of documents were furnished at page 44, my lord. My lord would find at serial number 2, letter from the Deputy Superintendent of Police CID, white letter dated 5/7/2017. So it is on the basis of that letter that a departmental proceeding was initiated against him. Then, my lord, he at page 53, my lord would find he submitted a detailed reply. My lord. Not troubling your lordship with the, because the merits, my lord, we're not going to, but he submitted a detailed reply. And after these exercises, my lord, if lordship comes to page 67, he was reinstated in service. Suspension order in terms of the orders of this honorable court was revoked and he was reinstated. Now, my lord, thereafter immediately, if your lordship can take up page 68. (25/1/2019), my lord has got it. My lord, here they have issued a fresh charge sheet. Show cause, sorry, my lord. Show cause. You are hereby directed show cause under Rule 9. So and so, why of any of the penalties and so inflicted upon following charges based on the allegation, etc. These charges are framed in addition to the charge already framed on so and so. Now, my lord would come to page 68E, my lord. the list of documents on the basis of which this was called. Show cause reply received from so and so. My first charge sheet show cause reply is now being used against me. The earlier show cause and my lord, the CID's letter, same letter, 5/7/2017. Now, my lord, there is a show cause notice pending. Now I have filed my replies. You take a call whether the charges are proved or whether it is satisfactory or not. If it is not satisfactory, go for an inquiry. Now, what they have done here is they got my reply. They came to a conclusion that my replies are not satisfactory. So they appointed an inquiry officer. That's the state inquiry officer. And the state inquiry officer, on the moment he gets this thing, he advises the department, no, file a proper charge sheet. File a proper show cause, issue a proper show cause against it. That power is not with the inquiry officer. My lord may come to the affidavit that has been filed by the excise department. Page 73, my lord. My lord, para 6. My lord has got it. That the deponent begs to state that the disciplinary authority was not satisfied with the reply of the show cause notice dated so and so, and therefore the state inquiry officer was asked to inquire into the charges framed against him. In fact, subsistence allowance dated so and so was granted to the petitioner to increase the allowance of the petitioner. The deponent begs to state that in compliance with the order of the so and so, the petitioner was reinstated in service and posted at so and so, what so and so. That the deponent begs to state that the state inquiry officer requested the department to frame the charges properly, and therefore a fresh show cause notice was issued to the petitioner. Now, my lord, the power of the disciplinary. My lord, page 426 of that, my lord, book. It starts, relevant would be, my lord, page 433, my lord. Rule 9. Now, my lord, comes to rule 9(4). On receipt of the written statement of defense, or if no such statement is received within the time specified, the disciplinary authority may itself inquire into the charges, into the such of the charge as are not admitted, or if it considered it necessary so to do, appoint for the purpose a board of inquiry or an inquiring authority officer. Then, my lord, 6. The inquiring authority shall in course of inquiry. So, my lord, after the inquiry authority is appointed, he has to take the inquiry forward. Now, there is a chance that my lord would find that rule 7, my lord. Proviso there too. Provided that. Sorry, my lord. Lordship, explanation, my lord. If in the opinion of the inquiring authority, the proceedings of the inquiry establish any article of charge different from the original article of charge, it may record finding on such article of charge, provided that finding on such article of charge shall not be recorded unless the government servant has either admitted the facts on which such article of charge is based or has a reasonable opportunity of defending himself against such article of charge. Now, this comes, my lord, after the inquiry is over. The evidences have been collected, and then the inquiry officer finds, no, there is another dimension to this whole thing. So he can put that question straight to the delinquent whether you agree. If he agrees, that's the end of the matter. He can proceed. If he does not agree, the procedure is it has to go back to the disciplinary authority. He will frame a charge to that effect and then give it to the delinquent. The written statement would be filed. And then, my lord, in pursuance, in this course of this inquiry also, that charge will also be considered. Now, here, my lord, on the very threshold, the inquiry officer is taking the role of the disciplinary authority, which, my lord, shows that there is something behind the whole charge against the applicant, against the petitioner. Now, why are they so? Because the only thing, my lord, they want to elongate the processes. When you don't have the power, and my lord, they have put it down in black and white in the affidavit, my lord, that the discipline authority had not decided that. The inquiry officer had decided that. If the inquiry officer has to decide it, he will have to complete the provisions of the procedure from 9(4)(9)(6). Then, my lord, total 9(6) he has to complete. He has to complete the inquiry. Thereafter, he has to give it, my lord. So, in that view of the matter, my lord, I'm not against the first show cause. I'll participate. Whatever, my lord, legal consequences follow, my lord, I'll bear that. But the second one, my lord, will not permit them to proceed, my lord. That has to be interfered with. And my lord, it is for them to frame a charge properly. If they are incompetent to do that, they can't. My lord, today they have done this. Tomorrow another one will come. So this has to be stopped. Let them proceed with the first charge. My lord, I have no, and my lord will put a time frame within which they should finish it. My lord. This is my humble submission.
Well, I have the original case records. The case is, my lord, canvassed by the petitioner doesn't, my lord, it's not like that, my lord. What has happened, my lord? My lord is very, my lord knows, my lord, charges cannot be vague, my lord. The first show cause notice, my lord, the first, which is a, this is not a second show cause notice, this is additional, my lord. That first show cause notice of 17 was very vague. And my lord knows, while judicial review in DP proceedings, my lord, charges cannot be vague. Because of the double-edged sword, it falls on the petitioner or the delinquent officer also, it falls on the decision authority also. My lord, what had happened exactly, I have the original records. My lord, when the first this was given, my lord, inquiry officers appointed, presenting officer also appointed, my lord. The charge, my lord, will see, my lord, these are very vague. 17, my lord, 2017, 18 August. I'll go to direct to the charge, my lord. Well, that says while I'm skipping one part, that while you are holding the post of Deputy Superintendent of Excise during 2012-2015 at BG Bonded Warehouse, Lokhara, Guwahati, you were found to be involved in defalcation of an amount of rupees 19.86 crores, my lord, as excise revenue apart from sales tax, as per the communication by memo number so and so received from the Deputy DSP CID Assam Ulubari Guwahati. Such conduct, my lord, this is the charge. This is the charge. Now, my lord goes to, my lord go to so-called alleged. This. My lord go to 2019 show. 2019, page 68. My lord will find that 17, my lord, it indicates BG Bonded Warehouse, my lord. It was very vague. Now, my lord, what has come? My lord has got 2019, my lord. My lord, see, relates to the same incident, my lord, not an isolated separate incident, my lord. Here, my lord, in 17, it was said, my lord, there was a defalcation of so and so. Then, my lord, 2019, charge 1, that while you are discharging government duties, deliberately allow dispatch of liquor from BG Bonded Warehouse to the culprits in spite of irregularities of transport permits / challans used by the accused for lifting the spirit. Such conduct on your part, so and so, being, and charge number 2, my lord, being responsible and senior government official whose duty was to secure revenue due to government not only failed to perform a duty for which you are posted, but also entered into criminal conspiracy with accused person for your personal gain. Such conduct on your part shows unbecoming of a government servant and shows negligence of official duty and violation of Rule 3 of Assam so and so rules. That, well, again, charge 3. That, see, this BG Bonded Warehouse is repeatedly used, man. It's being repeatedly used. That while you are posted at BG Bonded Warehouse during so and so, you are the part of conspiracy and therefore prefer to turn a blind eye to the rampant illegality going on during that period. Such conduct so and so. Again, charge 4. That while we are posted at BG Bonded Warehouse, the quantum of consignment which were lifted after being authorized by you was many times more than the consumption capacity of the wine shops of so and so district, my lord, and preferred to procure consignment for BG from BG Bonded Warehouse, which is located hundreds of kilometers away. This defies all logic and business sense / prudence, my lord. Such conduct of so and so, my lord, again, charge 5. There is no mention in Rule 30 of handing over the copy of the permit meant for exporting bonded warehouse to the person / owner / agent of the wine shop would collect the consignment from the bonded warehouse, that while you were posted at bonded warehouse, you allowed lifting of liquor on the basis of permits brought by hand, which is a clear violation of Rule 30 of so-and-so rules, my lord. Now, my lord, Rule 6, charge 6, next. That while you are posted at BG bonded warehouse, you allowed the accused person to lift spirit from the warehouse for their wrongful gain pursuant to the conspiracy which they entered with Judge Jalan and his accomplices. Such conduct against so-and-so. My lord, charge 7, that you did not cooperate with the investigation. Accordingly, we apprehended you are apprehended from a private guest house in New Delhi, so-and-so, and he was arrested and produced before the Honorable Court, so-and-so. And such conduct again, my lord, again, my lord, charge 8, that while you were posted at BG bonded warehouse, the accused persons in connivance with you lifted a huge quantity of liquor from the BG bonded warehouse to fake and forged transport permits and sold the same in open market, violating excise regulations and misappropriated 40 crores of revenue, depriving the government. My lord, see, in spirit, my lord, this is not a second show cause, my lord. This is no second show cause, just to, my lord, that it's for his own good, that my lord, charges have been explained very meticulously, so that he can define himself properly, my lord. That is his. And also, my lord, see that 17 show cause, because it merely states that while you were posted in BG bonded warehouse, you did so and so. This second letter, my lord, it explains, it gives it, because vagueness is a ground in which a court can interfere, my lord. So, my lord, at that apart, my lord, when the inquiry officer was appointed, inquiry officer, my lord, I'm handing over, my lord. What had happened in inquiry officer, my lord, appointed, inquiry officer says, with reference to the notification so and so, it is observed that, my lord, 1, no list of witness has been provided to the case records, 1, my lord. Second, no documents relating to the case has been provided to the case records, 2. The written statement of Sri Amarendra Nath, that is the petitioner, my lord, Deputy Superintendent Excise in respect of show cause notice has not been provided to the case records. 3. Number 4, my lord, the charge has not been framed properly. What my lord bounds us for that to proceed against a delinquent, my lord, that charges should be framed properly. There cannot be any vague charges. And, my lord, every small, my lord, detail should be looked into, because, my lord, I'm handing over. And I have flagged.
Inquiry officer have the authority to make all those.
My lord. Yes, my lord, he has. I'll come to that, my lord. First, my lord,
Documents,
my lord.
list of documents in the show cause notice by itself vitiates the whole show cause notice.
My lord.
Because you are using the show cause the show cause reply against the petitioner.
Well, I'm handing over.
And you have read video para 6 or 7.
Yes, it mentions the letter, man. It mentions the letter, man. It mentions the letter. Okay. And apart from that, I have quoted some citations, man. I'll come to that. First, my lord, will go through the original records.
This court is not stopping you from doing things.
My lord.
In terms
no, my lord, the case which has been canvassed, that this is second show cause notice, which has no connection with the earlier show cause, that is not, my lord.
No. I'm saying,
my lord,
you can proceed against the petitioner, but you'll have to proceed in terms of the rules of 1964.
No, we are proceeding. No, my lord, my lord, vagueness is a ground which
Yes, which is the letter?
My lord, all flag, my lord, all yellow are relevant, my lord, all yellow flags.
So well,
What the number of flags?
Yes, my lord. My lord will go through, my lord.
Take the whole day.
No, my lord. Very small documents, my lord. And that
my lord will only see the inquiry officer's note, my lord. It a page quit, inquiry officer.
Page, as per I recall, maybe 63. Since, my lord, it's a government record, my lord, I didn't, my lord, try to use my pen, my lord.
It's only he was on a black pen taking. Citation.
And my lord, Rule 9, which petitioner is harping upon, my lord, it says, after conclusion of inquiry, here the inquiry is not yet started, my lord. Evidence has to be adduced.
It says it is impossible to proceed with the inquiry.
That's the reason, my lord, because charges were vague. My lord,
I'll just clarify. My lord will see that my reply was not part of the record. List of documents were not part of the record. My lord will see there are many. They have not given him those documents. How will he proceed, my lord? But those documents are very much available. There was a list of documents. My reply was there. It was not given. So they'll have to give those documents to the inquiry officer and then he will proceed, my lord. So they deliberately don't want the inquiry officer to proceed.
I'll come to that, my lord. I'll come to it. And rule 9, my lord, if my lord has done reading, my lord.
Yes.
My lord will not read that in isolated manner, my lord. My lord will read with all the connected flags, my lord. To have a whole picture of what is going on.
Flags are here.
Not too much, my lord, not a dozen itself.
Show post notice only.
Time লাগিব, 5 মান মেছেজ আছে।
কিমান টাইম দিব? আধা ঘণ্টা? কোড নম্বৰ 8 কিমান ছিল? আমাৰ টাইম আছে। কি কৰিব?
এই ফটো নাই নিব। টাইমখন এইটো গ'ল।
Page 69.
I know. I'll come to that.
Page 69.
69, my lord.
What do you have to say against this?
69, I forgot my lord, what was 69, please.
This is inquiry officer telling the commissioner and secretary
My lord.
to frame charges.
Yes.
Specific accusation.
Yes, my lord, that is the point. DP cannot proceed on vague charges. I'll come to that, my lord. Cannot proceed. It's a double-edged sword which falls for the petitioner also, for the authority also. So when charges are framed, when DP will go on, how can we proceed? Neither it's, my lord.
So when this type of thing happens,
My lord.
then what does the rule say?
My lord.
What does the rule say?
Rules condition. My lord, yes. Rule says, my lord, that charges cannot be vague.
Let us see the rule.
My lord, rule 9, sub rule 2, at the time, my lord, it starts.
Rule 9.
Rule 9, sub rule 2.
Disciplinary authority.
Yes, yes. At the time of delivering the charges, the disciplinary authority shall invariably furnish to the government servant a list of documents and witnesses by which each article of charges is proposed to be sustained.
1 minute.
That's, my lord, after the two.
Rule 9(2) is something else here.
No, my lord, that part is at page 434, my lord.
Okay, that would mean.
In the box it is given.
Oh, yes.
I also difficulty at book. Rule 9, my lord, without page 1, my lord. I'm skipping 1. Number 2, my lord. The disciplinary authority shall frame definite charges, not vague, definite charges on the basis of the allegations on which the inquiry is proposed to be held. Such charges, together with a statement of the allegations on which they are based, shall be communicated in writing to the government servant, and he shall be required to submit within such time as may be specified by the disciplinary authority a written statement of his defense, and also to state whether he desires to be heard in person. At the time of delivering the charges, the disciplinary authority shall invariably furnish to the government servant a list of documents and witnesses which each article of charges is proposed to be sustained, my lord. My lord, the government servant shall, for the purpose of preparing his defense, be permitted to inspect and take extracts from such official records as he may specify, provided that such permission may be refused if for reasons to be recorded in writing. In the opinion of the disciplinary authority, such records are not relevant for the purpose of its or it's against the public's interest to allow him access thereto. Provided, my lord, so and so, yes. My lord, I'm harping on 2. And what my petitioner is harping on is after conclusion of inquiry. Here, my lord, inquiry has just started and evidence has not been taken. And my lord, I have a 2006-12 SCC. I have provided. 1502. 2015 to SCC, my lord.
612.
No, 15 to SCC. I have provided a list of books.
15 to SCC.
15 to SCC.
For the page,
610, page 610. It's Union of India versus P. Gunashekharan, my lord. My lord will come to para 12 and 13.
Oh, yeah.
Yes. It carves out, my lord, when a court can enter, a court can interfere, my lord. Para 12, it says certain parameters are laid down. Number 1, my lord, when a court can interfere, the High Court can only see whether, my lord, A, the inquiry is held by competent authority, that is not challenged. The inquiry is held according to the procedure prescribed in their behalf, that is there, my lord. There is a violation of principle of natural justice in conducting the proceedings. This
is after the proceedings are over.
No, my lord, it has carved out when you can enter, my lord. When you can enter. For a moment, my
After
lord.
the proceedings are over.
In that case, my lord, 2006-12 SCC. 612 SCC. In that case, my lord, I'll term the challenge of the petition as premature, my lord.
2006.
612 SCC, page 28. Para 14, 15, and 16, my lord. 14, my lord. The reason why ordinarily writ petition should not be entertained against a mere show cause notice, this is the case, or charge sheet, is that at that stage, the writ petition may be held to be premature. A mere charge sheet or show cause notice does not give rise to any cause of action because it does not amount to any adverse order which affects the rights of any party unless the same has been issued by a person having no jurisdiction to do so. It is quite possible that after considering the reply, my lord, it doesn't mean that, I'll read my. It is quite possible that after considering the reply of the show cause notice or after holding an inquiry, the authority concerned may drop the proceedings or hold that the charges are not established. It is well settled that writ petition lies when some right of any party is infringed. A mere show cause notice or charge sheet does not infringe the right of anyone. It is only when a final order imposing some punishment or otherwise adversely affects effective parties past, the said party can be said to have any grievance. Number 15, my lord. Writ jurisdiction is discretionary jurisdiction, and hence such discretion under 226 should not ordinarily be exercised by quashing a show cause notice or charge sheet. 16, my lord. No doubt, in some very rare and exceptional cases, the High Court can quash a charge sheet or show cause if it is found to be wholly without jurisdiction or for some reason if it is wholly illegal. However, ordinarily the High Court should not interfere in such a matter.
Absolutely right.
Yes, my lord. Yes. No, my lord. It's
the first show cause notice.
No, it's not
absolutely right.
I'll come to that. I'll also deal with that, man. I'll deal with it. 2003, 6, 1306.
It is also not applicable.
No, this is applicable, my lord, because this is a stage of show cause, my lord.
Show cause, second show cause.
No, my lord, this is second show cause.
Second show cause where you using the reply of the petitioner against him.
No.
That is the trouble. First show cause, he's not challenging.
My lord, no, my lord, my lord. In that alleged purported, my lord, in that purported show cause, no reference has been made. His grounds are not taken. My lord, I have clearly indicated that BG Bonnet first show cause, which just says that you have done so and so. But the second one, my lord, which purported the second one, it's an additional charge. My lord, that's not the second one. It is explaining, it is for his own betterment. It is for that he can come and reply.
whatever you submit, the list of documents,
My lord.
vitiates the second show cause notice. That's all, in short.
And then my lord, 2013 C cases.
2000.
Five on five. 515. Paragraph 15, my lord. Vague charges.
Paragraph 15.
Paragraph 15. In so and so, this court held that it is not permissible to hold an inquiry on vague charges. Those charges are vague, my lord, as the same do not give a clear picture to the delinquent to make out an effective defense, as to he will be unaware of the exact nature of allegations against him and what kind of defense he should put up for rebuttal thereof. The court observed as under my lord, the grounds on which it is proposed to take action have to be reduced to the form of a definite charge or charges which have to be communicated to the person charged, together with a statement of allegations on which each charge is based, and any other circumstances which is proposed to be taken into consideration in passing orders has also to be stated. This rule embodies a principle which is one of the specific contents of a reasonable adequate opportunity for defending oneself. If a person is not told clearly, my lord, this is in italics, and definitely what the allegations are on which the charges preferred against him are founded, he cannot possibly, by projecting his own imagination, discover all the facts and circumstances that may be in contemplation of the authorities to be established against him. Where the 16, where the charges are accompanied by statement of facts and allegations are not specific in the charge sheet, but are crystal clear from the statement of facts, in such a situation as both constitute the same document, it cannot be held that the charges were not specific, definite, and clear. The inquiry is to vitiate. Thus, now why should the delinquent be served the charge sheet without providing to him a specific, clear, specific, and definite description of the charge against him? When statements of allegations are not served with the charge sheet, the inquiry stands vitiated as having conducted in a violation of principle of natural justice. The evidence adduced should not be perfunctory, even if the delinquent does not take the defense or make a protest that charges are vague. That does not save the inquiry from being vitiated, for the reason that there must be fair play in action, particularly in respect of an order involving adverse or penal consequences. What is required to be examined is whether the delinquent knew the nature of acquisition. The charge should be specific, definite, and giving details of the incident, which form the basis of the charges, and no inquiry can be sustained on vague charges. The purpose of holding an inquiry against the person is not only with a view to establish the charges leveled against him or to impose a penalty, but is also conducted with the objective of such an inquiry recording the truth of the matter, and in that sense the outcome of an inquiry may either result in establishing or vindicating his stand, and hence result in his exoneration. Therefore, fair action on the part of authority concerned is the paramount necessity, matter. My lord, that we have, my lord will see, my lord will take up the first LS purported first so-called notice. My lord will take up again.
This is helping the petitioner.
No, it is no. That is why I'm saying, my lord, this is a vagueness is a double-edged sword, my lord. There is a double duty casted on both sides. We also cannot proceed. We also not want to. We just want to inquire what is going on actually, and to give him a better defense case, my lord.
You messed up your whole thing. You messed up yourself.
No, my lord will read again, my lord. My lord will read again the so-called charge, this letter of 2017. 17 letter, my lord, or 18 August.
2017 of
18 August 2017.
Which one?
Page 43, my lord. Read petition, my lord.
First show cause.
Well, see the charge. Charge is that while you are holding the post of Deputy Superintendent of Excise during so-and-so at the BG Messrs. BG Potato Lakhwara, you are found to be involved in defalcation of an amount of 19.86 crores as excise revenue, apart from sales tax, as the communication by memo number so-and-so received from DSP CID. Man. This charge has been explained. What his petitioner is harping on, my lord, this 19 letter, my lord. 19 letter, my lord,
I've seen
68, 68 F, 68F.
Page 68.
F. F or E. E. Oh. This, my lord, this explains about the same incident. That is the connected incident. That is the incident. 17 incident is referred to, my lord. This just explains, my lord, what actually, my lord, since I have read out, it is specific, definite, and giving details. This 19 letter lays down, my lord, what specific charge is against you, and details of the incident you are charged with. This is not the second show cause notice, my lord. This is the additional charge sheet which is explaining his charges to give him a better defense plea. That is the case. My lord, see the contents. My lord, compare the contents. My lord, again, my lord. Yes, my lord. Had there been, my lord, indication to some other incident, my lord, then the case would have been different. This is the case, my lord, which says this is the part of a. This is giving in detail, my lord, what actually you are charged with. That is my case, my lord. And that apart, my lord, since vagueness is a ground which a delinquent can rely on for quashing of a DP, my lord. So we also authority should also be very careful that charges should not be vague. And my lord, there is an implied power, my lord.
Where?
Implied power. I'll go on vagueness again. 1995 one SSC. One SSC, page 332, my lord.
It's on the report. $1995.
One SSC, my lord, 332. Transport Commissioner Mr. Radha Murthy.
Yes.
Para 9, my lord. Para 4, my lord. Para 4.
Para 4.
Para 4. The memo of charges first sets out the amounts misappropriated under the various heads in the state office during the FOC days, and then follow paragraph 4, 5, and 6, which read as follows. That is, my lord, in that case. Now, my lord, law has been discussed in para 5. In this case, my lord, petitioner was served with so cause. DP was initiated. That was with delay. Delay was the ground, my lord, and 3 grounds are taken. That the charges communicated are vague and not elicited by the statements of particulars or in any other manner. In any other manner, my lord. Para 5, sub point 1.
Yes.
Yes. That the 3 grounds were urged by the respondents in support of his FOC. 2 grounds are not relevant here. First ground, the charges communicated are vague and not elucidated by the statements of particulars or in any other manner. And my lord, para 9. Insofar as the vagueness of the charges is concerned, we find that it deserves acceptance. It is asserted by Shri Learned Counsel Respondent, except the memo of charges dated, so no other particulars of charge or supporting particulars are supplied. This assertion could not be denied by the learned counsel for the appellant. A reading of the charges will show that they were not specific and clear. They do not point out clearly the precise charge against the respondent which he was expected to meet. One can understand the charges being accompanied by statement of particulars others or other statement furnishing the particulars of the aforesaid charges, but that was not done. The charges are general in nature to the effect that the respondent, along with 8 other officials, indulged in misappropriation of by falsification of accounts. What part did the respondent play? Which account did he falsify or help falsify? Which amount did he individually or together with other named persons misappropriate are not particularized. This charge is a general one. It is significant to note that the respondent has been objecting to the charges on the ground of vagueness from the earlier stage, and he was not furnished with the particulars. It is brought to a notice that the respondent's name was not included in so and so manner. We are, my lord, paratem. We are therefore of the opinion that the judgment of tribunal is right insofar it holds that charges communicated to respondents are vague.
Exactly, this is when the
No, my
petitioner
lord.
comes to the court.
No, my lord, that
says
is-
that, see, these charges are vague. Here, this is not the case. Here he has made his reply to the show cause notice. You issued another show cause notice. Making the reply to be used against the petitioner.
No, my lord, we are not using anything. We are just.
How can
detail-
you say that? How can you?
Yes,
say
my lord,
something
because
else
I have
which is
read
not-
out these contents of both the letters, first and purported second. Read out, first one just gives a vague statement that you have defalcated while posted so and so. The second purported, second says additional, in my opinion, it's additional. It lays down what you have what is the procedure adopted to commit that specific, the specific that crime, my lord, that offense. My lord, just compare, my lord. Just compare. My lord, it will spell out that first. What was first letter, my lord? It says you just defalcated, well posted. But the second, it lays down that what is exactly what did you do? In what manner did you do?
Just show me the provision under the rules of 1964 that an inquiry officer can write back to the disciplinary authority to frame charges.
My lord.
To frame definite charges.
My lord, since the word is used, my lord, I have shown, my lord, this rule 9. My lord, because vagueness is a ground, my lord, inquiry cannot, my lord, therefore go on, my lord. Since, my lord, that letter speaks that charges should be specific, not vague. We admit that first letter was vague, just a vague allegation that you have posted so and so, you did this. How, when, in which manner, how much, it was not reflected there. That second letter, which is being assailed here, my lord, that second letter spells out what is actually going on, how did you do it? And that apart, my lord, there's a another judgment, that's final judgment. My lord. There's a 2008 2 SCC. 2008 2 SCC 409. Well, this will answer the question put to me that if the officer, this inquiring authority had the power to indicate that you frame charge. It's Sakiri Vasubala, state of UP. Para 18, my lord. Para 18, my lord. It is well settled that when a power is given to authority to do something which it includes such incidental or implied power, my lord, which would ensure the proper doing of that thing. In other words, when any power is expressly granted by the statute, this is impliedly included in the grant, even without special mention, every power and every control.
Yes, with regard to criminal proceedings.
No, my lord. Foundation may be criminal. Foundation may be criminal, my lord. But this paragraph, it doesn't. The periphery may be, my lord, criminal.
It is on section 156(3).
My lord.
CRPC.
My lord. No, the periphery may be, but what comes out from this judgment, my lord, this implied power is there, my lord.
Here you are governed by a particular statute.
Yes, my lord. So, my lord, that is why I'm saying the statute says you initiate DP on definite charges. So there is an implied power to the authority because authority says charges are vague. Says charges should be from, my lord, in a very good manner so that employee can defend himself properly. That is in letter and spirit, my lord. And this Sakiri was 18, 19, 20, 21, and 22, my lord.
I'll give you time. Read.
The reason for role of doctrine implied was quite apparent. Many matters of minor details are omitted from legislation, as Crawford observes in statutory constructions, my lord. Now, my lord, Crawford statutory construction, it's not criminal or civil. It's a book of statutory construction. If these details could not be inserted by implication, the drafting of legislation would be interminable process. The legislative intent would likely be defeated by a most significant omission. In ascertaining a necessary implication, the court simply determines legislative will and makes it effective. What is necessarily is implied is that part of the statute, as it was specifically written therein. An express grant of statutory powers carried with it by necessary implication the authority to use all reasonable means to make such grant effective. Thus, in so and so case, this court held that the income tax appellate tribunal has implied power to grant stay, although no such power has been expressly granted to it by the Income Tax Act. Similar examples where these courts affirm the doctrine of implied powers act. My case has been, this is our cases.
Okay.
And my lord, the petitioner is harping on Rule 9. Rule 9, my lord, that
Rule 9,
6.
6 and 7.
6 and 7.
The explanation there.
6 and 7. 6, my lord, read. The inquiring authority shall, in the course of inquiry, consider such document. That stage has not reached, my lord. To bring him under the umbrella of 6 and 7, that stage is still not reached. It's still at a stage where the show cause it. I have cited one, my lord.
That's why I'm asking
my
you.
lord. Such
Show me the provision where the inquiry officer can write back to the disciplinary authority.
My lord, that was harping on that implied power, because my lord, the disciplinary authority shall frame definite charges. He is not asking the manner in what will be the, my lord, the body of the charge. He is just indicating you frame definite charge. And Rule 7. At the conclusion of inquiry, inquiring authority shall prepare a report of the inquiry, recording its findings on each of the charges together, reasons thereof. That stage doesn't reach. 7 is yet to be yet to come. 7 is if in opinion of inquiring authority, the proceeding of inquiry establish any article of charge different from the original article of the charge. My lord, that is future. That is future, because it has to go on. Because for this to come into play, inquiry has to be started. Now it is still a stage where show cause is going on. Delinquent has to come, has to adduce evidence. Then inquiry official come to a finding that no, either you exonerated or I found that some separate charges there, you go in there. This is not the case. This is the case where, my lord, that charge sheet, first charge sheet, one charge sheet, and that second additional charge sheet, first charge sheet was vague, second charge sheet was in specific, it lays out details that what you are exactly charged with. And he has been asked to show cause, nothing else. He can again show cause, my lord. He can come to the authority. He can again come to the authority. Apart from that, my lord, see the defalcation amount. Amount 6 crores, my lord.
Yes, that I understand.
That's why the show cause is there.
No, my lord, in my humble understanding, I may be wrong, subject to correction, my lord. 7 and 9 has not even reached yet, my lord.
It has to reach.
It has to reach, my lord. Only, my lord, if it has to reach for, like, my lord, because the word 7, we are reading the explanation, okay. But my lord, 7, the heading, it reads at the conclusion of the inquiry, my lord. Can this explanation in the bracket be read, my lord, the isolated manner? No, it has to be read with the heading, my lord, at the conclusion of the inquiry, my lord. And number 6 also, that's 6, Rule 6 also, or inquiring authority shall in course of inquiry. In course of inquiry, my lord, take oral evidence that this stage has not been reached yet. Apart from that, my lord, vagueness is a ground which he will again come to the court. He'll say, no, my DP is vitiated now. That charges are very vague. To give a go by to that, my lord, we come out with this additional charge sheet that we say it explains the manner, procedure, and how much you are into it. That's all. That's
What more there on the reports?
my lord.
On the reports?
Record, well, that page I think only is required.
My lord, no. My lord will read from all. I'll travel, lordship. It will take some time. Lordship will read. Lordship will read all the yellow flags.
Synopsis of the morning.
And my lord, authority, inquiry officer doesn't take only one ground, my lord. There are some other grounds also. Lordship will consider those also. If Lordship desires, Lordship can hold back the record for some time, if Lordship desires.
I don't want to keep it CAV. I want to dictate it here.
No, my lord, 2-3 days if my lord was, if my lord finds it too bulky, my lord, because I insist, my lord, that, and I pray, my lord, that other flags should also be taken into account.
Yes.
My lord, only thing, my lord has got the issue. I've explained my position clearly. He says, my lord, list of documents not given.
But you can hire
Lordship.
a senior counsel, assisted by
Mr. A. Board.
then a counsel for petition. Also heard Mr.
D. Gogoi, my lord, standing counsel exercise.
D. Gogoi, and standing counsel exercise for the respondents. All the respondents.
All the rest.
All. The petitioner, while serving as a deputy commissioner of excise, Guwahati is, Kamru, was transferred and posted
My lord, I just need leave for a few seconds.
as
Obviously.
in charge superintendent of excise, Hailagandi, by a notification dated 18/6/2016.
That was interfered with.
That was interfered.
That was interfered. No.
Petitioner was placed under suspension by an order dated
24/5.
24/5/2017 with immediate effect. With immediate effect. You approached this court, correct?
No, my lord, then I was placed under arrest, my lord.
Petitioner was,
Thereafter,
where are the documents?
my lord would find at page 24.
Petitioner was,
Date and time of 10/6/2017, I was placed under arrest, my lord. Page 24, there is the arrest memo. In connection with, my lord,
petitioner was arrested
Lordship.
in connection with CID
PS case number 54 of 2015, my lord.
54/2015
15.
under section 120 within bracket B /468 /471 /409 IBC
Lordship.
and read with section 13 within bracket 2 PCA. Stop.
Then, my lord, I was granted bail, page 39
No,
on
no, after
20.
that only you were placed under suspension.
I was placed under suspension before arrest, my lord, 6/1. Then 21/9/2017, I was granted bail, my lord, page 39.
Thereafter, petitioner was granted bail on 21/9/2017. Passed by this court.
Then, my lord, my suspension, then, my lord, that show cause came.
Your revocation was only after the show cause.
A lordship.
Petitioner was notice dated 18 August 2017 on the charge that while he was holding the post of deputy superintendent of excise during 2012 to May 2015 at the MSBG bonded warehouse, Lokhara, Guwahati. He was found to be involved in defalcation of an amount of rupees 19.86 crores as excise revenue apart from sales tax in terms of the communication dated 5th July 2017 received from the Deputy Inspector of Police, CID, comma, Assam, Guwahati. Stop. Apart from the show cause notice, no list of documents was furnished to the petitioner. However, subsequently, the same were furnished to the stop. Accordingly, petitioner made his reply to the show cause notice on
22/4/2018.
Stop. This what happened?
My lord, after that, the order of this honorable court on 16/11/2018, page 61, my lord, in WPC number 7556/2017. That suspension order was interfered with. My lord.
In the meantime, petitioner approached this court by filing WC 7556/2017, challenging his suspension order. The same was
Interfered.
disposed of by this court on 16/11/2018, setting aside the suspension order into 24/5/2017.
Then I was reinstated, my lord, on 21/2/2019, page 67.
Accordingly, comma, petitioner was reinstated back into service with immediate effect and posted at Barbat Jora, Kokrajhar district as Deputy Superintendent of Excise by a notification dated 21st February 2019. Where is the appointment of the prosecuting?
That my lord would find in the records. Ma'am. There would be a note sheet.
Notification.
Order or not sheet?
But that's the order by the governor, notification. I don't recall, I can, my lord, if you give it back to me, I can. Oh, no, wait. Take the version back.
Oh.
Yes. By notification. It is 27 December 2017. The inquiry officer and the presenting officer were appointed. Draft. The inquiry officer by letter dated 13th April 2018, wrote to the Commissioner and Secretary to the Governor of Assam Excise Department, within bracket Disciplinary Authority. Correct?
Lordship.
Observing that A, no list of witnesses have been provided with the case reports. Comma, B, no documents relating to the case has been provided with the case reports. Comma, C, the written statement of the petitioner in respect to the show cause notice has not been provided with the case reports. And D, charges have not been properly filed. Accordingly, the case report was returned with for taking necessary action. Stop. By another letter dated 25th June 2018, the inquiry officer again wrote back to the disciplinary authority requesting to frame the charge properly against the petitioner by mentioning specifically the rule of the procedure, etc., that has been violated by the delinquent official, for which he is charged with specific accusations. The letter further stated that it is not possible to prove or disprove a charge if it is not framed properly. Consequently, the another show cause notice was issued to the petitioner by on 25th January 2019, where in the list of documents, the show cause reply received from the petitioner on 22/4/2018, and the earlier show cause notice dated 18/8/2017 were listed along with other 5 documents. Stop. Being aggrieved with the second show cause notice dated 25th January 2019, petitioners before this court challenging the same on the ground that the show cause reply made by the petitioner on
Show cause reply is on, my lord, 22/4/2018.
22/4/2018 is being used against it, and the same vitiates the whole proceeding. Vitiates the second show cause notice dated
25/1/2019.
25/1/2019. Basically, does the whole thing.
And further, my lord, that power is not there. The inquiry officer
Further,
cannot.
It is the case of the petitioner that the inquiry officer does not have the power to write back to disciplinary authority, directing him to frame fresh charges in terms of the Assam services within bracket disciplinary appeal rules.
It can be done only after the stage at 9/6, after the inquiry is completed.
The senior counsel for the petitioner submits that if any further steps are to be taken, same has to be done after the conclusion of the inquiry in terms of rule 9 within bracket 6,
And the explanation.
and thereafter may proceed with the procedure laid down in rule 9 within bracket 7, particularly the explanation made thereto. That's all.
That's it.
So, Mr. D. Gogol, Standing Counsel Excise Department, however, submits that the second show cause notice dated 25th January 2019 are
Additional.
is in additional show cause notice, supplementing the first show cause notice by framing definite charges against the delinquent officer. Stop. He therefore submits that as the disciplinary processing is yet to commence, no interference is required in the supplementary show cause notice dated 25th January 2019. Stop. Learned counsel for the learned standing counsel for the excise department has also placed reliance in the case of Union of India and others versus the Gunasikara reported in 2015 to SCC 610. Then we see this Union of India and others and another versus Gunusika Satyanarayan 2006 12 SCC 28. Then Anand K. Kulkarni, YB Education Society and others 2013 6 SCC 515. And the other one was
1995, madam. 95, 1 SCC. 332.
1995. Okay, 1995.
1 SCC, 332.
332.
And my lord, 2002, my lord, 2008, 2 SCC.
2008 to SCC 409. I've considered the submission forwarded by the council. This court has also perused the reports produced by the learned standing council. Para. The Assam Assam Services Discipline and Appeal Rules 1964 within bracket here after rules of 1964 and short. No, it does say rule 9. Rule 9 of the Assam Services provides for the procedure for imposing penalties and the process of the disciplinary proceedings that are to be stopped. Rule 9(6) and 7 are reproduced here. 8. Stop. On perusal of the reports produced by the standing council, this court has considered the letter dated 13th April 2018 written by the inquiry officer to the disciplinary authority, and the same is also reproduced. That will be page 63 of the reports. Further, comma, the letter dated 25th June 2018 is also reproduced here. That is page 69 of the reports. Perusal of the second show cause notice dated 15th August 2017. No, dated 25/1/2019. Does not indicate that it is a supplementary show cause. The same clearly indicates that this is the fresh show cause notice and the show cause reply, which was made by the petitioner against the first show cause notice dated 18th August 2017, is being used against the petitioner. The affidavit in opposition filed by the respondent number 2 has also been perused. And para 6 of the state affidavit in opposition reads as under. Para 6, page 17. Stop. Subpara. In the said affidavit, in para 6 as reproduced here in above. Stop. It is clearly stated that the state inquiry officer requested the department to frame charges properly, and therefore a fresh show cause notice, was issued to the petition. The perusal of the affidavit in opposition and the submission of the learned standing counsel excise department is contrary inasmuch as it is a fresh show cause notice in terms of the affidavit in opposition and not the supplementary show cause notice issued, not the supplementary show cause notice. Stop. Para. The authorities cited by the learned standing counsel have been considered by this court. However, in my opinion, the same has no applicability to the case at hand, and in fact, it supports the case of petition. After the show cause notice, first show cause notice dated
18/8/2017.
2017 was issued. It was incumbent on the part of the inquiry officer to have proceeded with the disciplinary proceedings and thereafter bring it to its logical end. Stop. While bringing the same to its logical end, the inquiry officer had come against any article of charge that were different from the other article of charge. It was open to the inquiry officer to proceed in terms of the explanation to Rule 9(7). This has not been done. And in fact, the inquiry officer, before proceeding with the disciplinary procedure, had written to the disciplinary officer for framing specific charges, which is not provided in the rules of 1960. In view of the above, I am of the opinion.
25/1/2009.
And is according Washington. However, this court is not interfering with the first show cause notice dated
18/8/2017.
August 2017, and the inquiry officer is directed to proceed with the disciplinary process in terms of the first show cause notice and conclude the same within a period of 3 months.
6 months, my lord.
No, what, 6 months?
No, my lord, 6 months.
My lord,
At
I'll
least
show from the
that can be
manual.
given to me, my
No,
lord.
no,
6
no,
months, my lord.
why should be
Because, my
given?
lord,
Manual is there, my lord. There is a manual here. and
that
the
is
manual
not a
knows the
disputed
bill.
case, my lord.
That's the manual, my lord. Manual
That is not a
says,
disputed case.
Within a period of 4 months
4 months, my lord.
from the date of receipt of a copy.
and they'll conclude the proceedings within 4 months, my lord. Proceeding including passing of the orders, my lord.
I'll be giving this for
Yes, lordship. Lordship also, I contended that rule that 967 doesn't cover him, my lord.
Much obliged.
You were saying 1995, no?
Yes, yes.
The second show cause notice, now the matter is over, is more vague. Here at least 19.86 crores is there. There it's nothing.
Acknowledgement.
Madam, in this matter, instruction is avoided, my lord. Yeah. So, madam,
That may
sometimes
be given, the fixed date may be given, because the case is to seniority.
Yeah, Mr.
Dear Prime Minister.
But DFA Ahmad, Learner Council for the petition. Mr. Lee Sharma, Learner Standing Council.
For secondary education department.
Secondary education is
I'm
allowed-
appearing on behalf of both.
is allowed. How much time you require?
14 mileage, 14 feet this matter on 14.
How much time do you require, you Sharma?
2 weeks.
Is allowed.
Earlier also they took time.
MSRDB, Learner Council appears on behalf of respondent number. RDB, you are for?
KDB, madam. KDB for respond number 4.
Respond number 4. Place the letter again on. Let it be 16th. Or
Your lordship. The petitioner is against non-mention of a name, the benefit.
My lord, in this way, R. Muzumdar will appear, my lord. He is in leg on code number 22, my lord. So kindly sometime. I
Yeah, please, your worship. This is second round of litigation matter regarding the seniority of the petitioner. Petitioner received the graduate scale from 2012 matter, but the respondent treated it that 2000 he received the graduate scale from 2016 matter, and that's why petitioner approved before
the other side.
He is come.
She is there. It may be time being matter.
No,
Let her.
yes.
You proceed.
In that case, your lordship may kindly peruse the appointment order of the petitioner, my lord.
Where?
Your lordship may find it at page 24, my lord. He was appointed as assistant teacher in the science graduate F.A. Ahmed MEM school, my lord, on fixed pay of rupees 2,000, my lord. Subsequently, his service was regularized as per order dated 21 October 2010. Your lordship may found it at page 29, my lord. He is at serial number 220 at page 31. Ajit Das, my lord. That is the petitioner. 220. Thereafter, he was allowed to draw regular prescribed scale, my lord. That is at page 33, my lord. With reference to the subject cited above, I have forwarded here with the DDO wise and treasury wise backup of the OBB upper primary and treasury under your jurisdiction for allowing draw prescribed scale of pay to the teachers concerned in favor of the necessary action, my lord. Accordingly, he received the salary, my lord. And subsequently, school was amalgamated in the year 2017, my lord, at page 38.
38.
Yes, my petitioner is at serial number 21. Thereafter, petitioner was deputed for
He was amalgamated as?
my lord, appointed as assistant teacher, my lord. And subsequently, he obtained a B.Ed degree from Guwahati University, which is at page 42 and 43, respectively. my lord. And Indian seniority list is at page 44, my lord. That is prepared by the school, my lord. As page 44, my lord, petitioner is at serial number 4, Ajit Das, my lord. And here, my lord, date of receiving of graduate scale is 1/4/2016. Your lordship got it?
Yes.
That is the intent, my lord. Subsequently, petitioner approached before this honorable court, which is at page 45, the order, my lord. Page 46 is from relevant, my lord.
Yes.
And accordingly, speaking order was passed. Speaking order was passed on 28/2/2022. That is at annexure 49, my lord.
Yes.
May I read, my lord? As per detailed report, that is from para 4, my lord. As per detailed report submitted by the Inspector of Schools SDC Task Force, Sri Ajit Das was initially appointed assistant teacher of F.A. Ahmed Dami Madrasa, Bishwanath Bait, DEO Sunitpur order number so and so. Fixed pay of rupees 2,000 per month against post created by government letter number so and so under OBB scheme. Later on, his post was regularized by government order number so and so dated 21/10/2010. After completion of DLED course from Diet Bishwanath, he was allowed to drop escape the scale of pay by the DEO Sunitpur by letter number so and so dated 6/2/2012. Thereafter, he has been drawing salary and allowances regularly as per rule. As per record, Ajit Das has been drawing grade of 6,800 intermediate scale till 31/3/2016. In the meantime, F.A. Ahmed Ami Madrasa Bishwanath was amalgamated with F.A. Ahmed Ami Madrasa Bishwanath by this office order under memo number so and so on 16/2/2017 under Shiksha Ketra scheme. Sri Ajit Das obtained his B.Ed degree on deputation in the year 2020. It is seen from the report submitted by the Inspector of Schools SDC Task Force that the name of Ajit Das assistant teacher F.A. Ahmed High Madrasa Bishwanath was not included in the graduation list of eligible teachers for promotion to the vacant post of headmaster in high school, since he does not have 10 years of teaching experience as graduate teacher. Hence, he is not eligible to be included in the graduation list as per Rule 14(2) of the Assam Secondary Education Provincialized School to Service Rule 2018. As per record, he has been drawing graduate skill pay of rupees 1/4/2016. In view of the above, the claim of Ajit Das regarding non-inclusion of his name in the graduation list of eligible teacher for promotion to the vacant post of headmaster in high schools of Sunitpur and Bishwanath districts as on 1/1/21 prepared and published by the Office of the Inspector of Schools SDC Tashpur cannot be considered and hence rejected, my lord. That was totally illegal, my lord. Your lordship may kindly found it page 51. And or my original portion is page 52. Page 52, your lordship. Existing pay structure pay bond to 5,200 to 22,000 plus 2,700. Basic pay pre-revised structure PB and GP on the date from which revised pay structure is applicable 6,930 plus 2,700 plus 9,630. Pay bond 18,300. Revised basic pay 27,530. Initial pay fixed at rupees 27,530 on 1/4/2016. Date of increment 1/7/2016. Now your lordship may come to ROP rule, which I have annexed at page 57. ROP rule of 2017. And 58 is the important measure. As graduate teacher of higher secondary, that is at page 58, graduate teacher of higher secondary high schools, assistant Vidya Mandir Gyan officer.
Where is that?
They are existing.
Where is that?
That is at page 58, my lord. Assam School Services Junior Class 2.
Assam School Services Junior Class 2. Yes.
Class 2.
Yes.
Graduate teacher, my lord. That is pay bond 2, my lord. 5,200, which the petitioner has been receiving, my lord. That is the existing, and that was revised on 14,400 and 49,000, my lord. That was revised in the year 2016, my lord. And 2010 onwards, he is receiving the 12 onwards, he is receiving the graduate scale, my lord. That I have also annexed the service book, my lord. Your lordship may found the service book at page 61 onwards. At page 64, my lord. Allowed to draw regular time scale. Page 64, my lord. Allowed to draw regular time scale of pay rupees 5,200. That is the graduate scale, my lord. GP 2,500, rupees 7,700 per month, and regularize the service by DS number so and so on successful completion of second semester of second year of basic training by order number so and so dispute so and so so and so. And revised order is at page 67A, my lord. That is here his pay was fixed. Fixation of pay under Assam Services Revision of Pay Rules 2017. Your lordship may got it page 67. Page 67A.
Yes.
Fixation of pay under Assam Services Revision of Pay Rules 2017. The scale of pay rupees 14,000 to
67.
page 67A, my lord.
I don't have 67A.
Next page, 67, next page. It's
Next
not-
page,
It's not
ma'am.
numbers.
Next
Page
page.
68.
Page 67, my lord. In my
Not numbers.
in fact, that is no number, my lord. I think.
I have a numbered page 68.
68.
It's
Second copy.
And what happens to the next page?
Next page is only one.
I think you have to do some pagination.
Yes, my lord. The
Okay. Mr. Ayala,
my lord.
General Counsel for the petitioner is permitted to rectify the pagination in the petition in the presence of the joint registrar. List after 1 week.
My your lordship may kindly fix the date, my lord. I have some urgency.
9th March.
My lord.
Obliged, my lord.
May it please Lordship, my lord. It is a case of selection of principal, my lord. In JB College, Jorhat. The petitioner is already working as principal, my lord. In
charge.
No, regular selection. My lord, there was a selection process. Let me be very candid, my lord. In a selection of process, unless there is allegation malafide, court does not sit in appeal. It is a series of decisions on the Supreme Court and the High Court also. But here, from the beginning, I have been alleging malafide through letters and also in the petition also. To show that the candidate who was selected, is not qualified under the regulation of the UGC. So, my lord, starting from Annexure A, petitioner is, my lord, under the UGC regulation, a person can hold a post of principal in one college for only 5 years. Then he has to apply the fresh and get selected if he wants to continue as principal. Otherwise, he will revert back to his post of professor. He will no more be principal. So that period is 5 years only. So, my lord, the petitioner was principal since 2019 in CKB College, Commerce College, Jorhat. Then there was an advisement on annexure B, page 22, dated 7/3/2022, for selection of an appointment of principal in JB College, Jorhat. And there he applied. And his application accepted. And he along with others were called for interview. We faced the interview on 11/4/2022. But in the the selection board meeting where he faced, okay, he found that there was some bias among some members, including the chairman. And immediately on 13/4/2022, he made a representation challenging the impugned resolution or impugned selection dated 2 days before 11/4/2022. There is my annexure D, page 25, 13/4/2022. Then, my lord, the annexure E is the page 28, guidelines, procedure of selection of principal issued by the Director of Higher Education.
Yes.
First, I will start those knowledge, then I will come one by one. Then annexure F. This annexure is really important, my lord. These are the guidelines procedure, how to select a principal. There is, of course, by the director of the state. Then F, certificate of teaching experience and other administrative experience, including his total experience in the and qualification, is page 30 to 57. It is a long details, matter, page 32 to 57. Then annexure D, he made a request for furnishing a copy of the selection proceeding dated 11/4/2022. There is 19/4/2022, page 58. Then Mahal will come annexure H, page 59. Demand for letter written by the JB College principal to the president to the DHE. The JB College is the college where the selection is to be made and appointed, the principal. And the under the rules, my lord, the governing body president of the college where there is vacancy and appointment should be made is the member secretary of the selection board. So he writes a letter, annexure H to 59 on 22/4/2022 to DHE, saying that R12, respondent 12 should be appointed. The person was yet to be out. Then, my lord, against that, the respondent 4, he was the main person, the secretary of the board of selection. He files a counter. That also, my lord, I have paginated the pages serially. He has also numbered as annexure A, B, C, page 76. He also annexes an advertisement that is already there. Individual marking pattern he has of candidates he has shown, annexure B. Then again consolidated markings of by members. Then competitive set of candidates. That I will come later on. Then, annexure the proceeding of the selection 11/4/2022 was announced. Resolution was made on 18/4/2022. Appointment of R12 written to DHE by R4 president. Appointment for that he writes to the DHE in advance that you please appoint R12. Then follows the appointment of the R12 pilot is on 27/4/2022. Page, my lord, 100 serial. Designated page 1. Page 100. internal was 40 my lord, and H. In excess with the authority conferred under provision of Rule 5(1) and 7(a) C of the Assam College Employees Professional Rules 9 2010, and on the basis of the recommendation of the selection committee and the governing body's resolution number 1 dated 1841, the undermentioned person is hereby appointed as principal of JB College, Barpatra Ali, District Jorhat, with following terms and conditions. So, my lord, the R12, Dr. Utpal Jyoti Mahanta is appointed as principal. Against that I am here, against the proceeding as well as this one. Now, my lord, in the affidavit, counter affidavit of R4, the president of the college, you will also kindly come to, I will start from there. Page would be 131, my lord. 131. 131 is the annexer. Just a minute, sir. Paragraph 8.
Reply affidavit.
No. Counter. The affidavit starts at page 61, serial 61. Page 69 also. Page 69. It is division. Yes, you also got my lord.
Yeah.
Page 69, paragraph 8 of the counter by the.
I think something is wrong with your petition. Paragraph 8 is page 68.
My lord?
Anyway.
Anyway, paragraph 8. That while denying the statement made in paragraph 11, my allegation against him was in paragraph 11 of my petition, petition. Of the petitioner, the answering respondent begs to state that the API score of the respondent of 12 is 256.48. The respondent 12 has 12 numbers of research paper publications in journal with Scopus site in his name, whereas the minimum requirement is 10 number research publication. It is said that as per the advertisement, there was no requirement for an incumbent to appoint as neither coordinator. So, my lord, he is told here a serious lie. He has got 9 publications in his favor. I have obtained the Scopus this site. I have got 19 and mainly 12 I have got. He has got 9. So what the UGC regulation matter, I have given the copy of regulation matter. Page 61. Publication. There you go. Page 61 of the UGC regulation framed under Section 26 and 14 of the UGC Act 1956.
Yes.
Here, my lord, college principal and professor grade, Roman V 5. Have you lost what, my lord? Yes. Number 1 is PhD. He must have PhD. I am PhD of 2003. He is of 2016. Then professor, associate professor with a total service experience of at least 15 years of teaching, research and in universities, colleges and institutions of higher education. There were minimum 10 research publications in peer-reviewed, pre-reviewed or UGC listed journals. A minimum of 110 research scores as per appendix so and so. So he's got a 9. I'll show a lot of from the Scopus site I obtained online. 8 minor. A lot of only come to page 131, perhaps there it may be 130 also, madam.
Page.
Mine is 131, annexer M1.
Mine is 129.
How is this? Then I think subsequent officers interesting. Mahanta Utpal Jyoti, Shivsagar College, Joysagar. Matrix overview. 9 document by author publication. And I have got my lord Sharma Ranjit, page 133, annexer 2, M2. There may be some different page.
Yes.
19 M2, my lord.
Yes.
The overview, documents by author, 19. This is mine, Ranjit Sharma, Dr. Ranjit Sharma. So, my lord, on this count alone, he was not qualified to be called for interview because he must have 10 publications in the review of the UGC. As for the regulation of UGC. Now we'll also kindly come to answer one by one. Then I have replied to his counter, my lord. I have said the same thing, my lord, that he is not qualified to be appointed or selected or even called for interview. That is there, my lord. Para 8 of my reply. Then he has less administrative experience, only 8 years. I have got 13 years, 4 months, and he has got only 8 years. 8 years, 8 months. Paragraph 12. Then petitioner PhD 2003, he is 2016, but there is some query whether he had taken permission for higher studies under the study rules. If that is not that, then he will be liable for punishment under Rule 13 of the Conduct Rules 1965. He must seek permission, study leave for studying PhD or any other degree higher education. That plea I have taken. My lord, now they will harp on one document, my lord. That your lordship kindly see page 103. Office memorandum. What is the position? Hundred three. And 11 page is 104 also. Office memorandum.
No.
My business and office business in the first one.
Your memorandum is where?
My
103 of our affidavit of respondent number 4, my lord.
Yes.
103.
103.
Last page of the affidavit.
Annexer J.
Yes.
The memorandum next page, my lord. Office memorandum dated 15 December 2021. Page 104. The Education Department, Government of Assam is pleased to notify that any government employee who has been selected and appointed for any state government job under Education Department, both teaching and non-teaching, is not allowed to apply for any other state level government job in the same position grade up to a maximum period of 3 years. And 3 years. And in case it is detected at any stage that any such state government employee has violated this OM, then appropriate departmental action will be taken against the employee concerned. This supersedes the earlier notification. But it was not published in any gazette or anything. It was the internal document they have annexed, saying that, my lord, that I don't have right to apply because I am already holding the post of principal in CKB College, Jorhat. Now, my lord, in spite of that, they called me for interview, accepted my application, and allowed to participate me. I was appointed, my lord, as principal. By the time I think I have concluded 3 years also. Anyway, so my plea on this count is that they have waived or relinquished this memorandum. Otherwise, they would never called me. They would have thrown my application at the doorstep, at the very first stage. So since they allowed me to participate, then proceeding was on and proceeding was announced, selection procedure proceeding was pronounced. So, my submission is that either they have waived or relinquished or amended, because the lawsuit knows that 2001 decision of Supreme Court. Perhaps Mr. Chaudhary was also there in Supreme Court in Subba's associate case, the lottery case. In there, my lord, in spite of default by the lottery holder, he was allowed to continue. Then Supreme Court gave the definition of what is abandonment. 2001 5 SCC. That is the document they want to create a barricade on my way to another selection. Page 629, my lord. The relevant portion of my lord, the definition is paragraph 16A. Is 646. Below. Ultimate paragraph. Whoever involves a conscious, voluntary, and intentional relinquishment or abandonment of a known existing legal rights, advantage, benefit, claim, or privilege, which except for such a waiver, the party would have enjoyed. The agreement between the parties, this is separate, because in spite of the agreement having lapsed and he became defaulter, he was allowed to continue the lottery. There was a case. So, my lord, here my plea is, my lord, that they waived this, the government has waived this memorandum so far I am concerned, and I was allowed to participate in the proceeding, self-proceeding. Now, that having been done, that is the preliminary objection they have raised. Now, let's kindly come to advertisement, page 22. Page 22.
I thought he has concluded. He said, no, you bring another 2 hours.
Because lot of documents and things to use on. Page 22 is the advertisement, my lord.
As such, my learned friend is taking a risk. What has been assailing the writ petition is the selection board minutes. Subsequent appointment, etc. is not under challenge, my lord. So that is a risk my learned friend is taking. I just pointing
If
out.
the proceeding goes, my lord, the appointment also goes. If the proceeding goes, my prayer will kindly be seen. Because it is, since I have alleged malified, my prayer is page 18, my lord, in the premises aforesaid. It is therefore most humbly prayed that your lordship may be pleased to call for the records and issue rule calling upon the respondents to show cause as to why a written nature of success should not be issued to pause and set aside the implement proceeding that is so and so of the respondent authorities in forwarding the name of the respondent number 12 or any action proceeding to accommodate the respondent 12 to be to the post of principal JB College, Jorhat, and further to show cause as to why reading the nature mandamus should not be issued directly commanding the respondent to consult the person. So I have already said that any action taken on the basis of proceeding should be passed. And I have named the respondent 12. Now in advertisement annexure, here page 20, 22.
Yes.
In pursuance to the permission for advertisement for filling of the vacant post of principal of provincialized colleges accorded by the Honorable DHE by so and so. Dated 9/2/2022. Applications are invited with complete biodata of all supporting testimonials from SSLC onwards for intending candidates for the post of principal JB College Jorhat, Autonomous Jorhat, Assam through proper channel having qualification, experience, latest norms, etc. of so. So here it is my lord, master's degree for the PhD, essay professor. These are everything is given. This is the advertisement. Against that I applied. And my application accepted. Then this is the my page annexure C page 23 is the my lord rules. 2017 my lord, that brought about amendment to the 2005 rules for selection procedure for principal. Annexure C page 23. And this rule was issued my lord in terms of the UGC regulation 2010, which was done away with by the UGC regulation that I have handed over of 2018. So that has been changed. So under that this was issued in terms of that. Under the College Provincialization Act 2005. Here, my lord, the amendment being brought about is in Rule 5, the existing sub Rule 1, the following be substituted, namely, appointment of the post of principal shall be direct selection on rising of a vacancy to the post of principal. The governing body of the college shall seek approval for conducting selection process from the director. On receipt of the approval, the college shall advertise the post in at least two prominent regular newspapers, including an English daily, having wide circulation in the state, giving a list 15 days time. So here the advertisement should be made, giving 15 days time to the intended candidates to apply, and accordingly the candidates have applied. Then amendment rule 3 below. There shall be a selection committee. It is not really. The principal for the principal by direct recruitment in the various provincialized colleges. The selection committee consists of the following. The vice principal and others, there are about 12 members. Now, my application wallet 13/4/2022. After having appeared in the interview, I gave this letter to the director, to the president governing body, and appeal against any approval to the proceeding resolution of selection committee held on so for selection so, where I have strong apprehension that I may not be selected for appointment. With reference to the above, I humbly beg to state as follows: for your kind consideration and action, with a request not to approve the proceeding of the selection of principal. That sir, under the aegis of the Disciplinary University Selection Committee for selection of principal of college was constituted, where I along with other faced the interview for selection of principal of the college, said college in selection committee meeting held on 11/14. That sir, although I had fared very well to the utmost effort in the interview, I apprehend from the words and conduct of some of the members, this is important, of the interview board, that I would be placed at serial number 2 and Professor Utpal Mohanta of Shivsagar College would be placed at serial number 1 and Utpal Mohanta is respondent 12, who has been appointed by raising about 2 marks. In this, if this is so, then there are serious anomalies in the selection. Thus, sir, compared to my eligibility, qualification, teaching, working, and administrative experience, I stand far above 2 other candidates to entitle me to a placement of serial number 1 on merit. Thus, sir, if what I came to know and apprehend comes correct, in spite of my qualification and experience, I have reason to believe that justice has been denied to me, which will certainly affect mentally, driving me to depression and frustration. That's a to lay before your honor a short resume of my qualification and experience, writing and research works. Your honor would certainly appreciate that the selection and marking pattern was not up to the mark if my appearance comes true. And that has come true ultimately when it was. Sir, I passed the MPhil in 1993, MS in 1999, MPhil in 1995, and PhD in 2003.
That may not be required to reach.
No, my qualification is required to compare how much administrative experience he has got and how much he has been given mark. How much of experience I have got teaching and administrative experience. That then published 30 plus research papers and international reputed journals with impact factor. Joined in my service in selection lecturer at JB College in 1997 and completed 21 years, 8 months served in the said JB College before I was selected and appointed principal at CKB College, Commerce College, where I joined in 21/8/2019 and continued till date. I was IQAC coordinator for 4 years, head of Department of Physics for 6 years, 5 months. I was recognized as PhD supervisor of the university, and under my supervision, 3 students got PhD under the university. He has nil. Respondent 12 has nil. I am also author of a number of books and articles which merited international and national level recognition and publication. Sir, needless to say, under my continuous effort and initiative, JB College got autonomous status. Sir, Your Honor also knows that to be a lecturer teacher in JB College for anybody is a matter of pride. From this college, dozens and dozens of state, national, and international level doyens have come out and shown in their state, national and international fields at various streams. That's in 21/8/2019 on my selection on merit. I was appointed as the principal of CKB College, so I am working till date. That's sir. In spite of such qualification in my favor, I might remain out of selection for appointment on merit. That's I have sense of grievance that the selection committee not only violated in marking patterns where subjective marking systems heavily predominates the objective one, as would be clear from the guidelines of marking procedure for selection of principal in degree colleges issued by your honor. 80 marks out of 100 is on subjective satisfaction of members of the selection committee. Only 20 marks is on objective marking. Such a heavily dosed subjective marking system has reason to be tinged with favoritism and selection process. So this was my first objection to the director. Then that come to ultimately. That ultimately come. Now can see my lord. Page page 30 to 57. Page 28 is annexed is my lord the marking pattern. Then my lord 29, how much marks it evaluated? How? Here, my lord, objective is only 20 marks in total. Subject is 80 marks. So that I'll show it, compare it with the marks I have been given. How there is anomaly in the marking also. The very procedure of selection, the process of selection is dented. Now, here, how much marks one would get on administrative experience, on teaching experience, on ability to express, etc. Now, your lordship will kindly come to page 30. 30 to 57. Certificate of teaching experience, my lord. My teaching experience is 21 years, 11 months on 20th August 1919. Then research experience, I have annexed, my lord. Annexed page 31. Total 15 years. Then, my lord, is UGC regulation, academic performance indicator API, based on performance. This is a main thing, my lord, which requires. But they will not maintain anything.
Not a member.
No.
Difference of 7.5 months.
So, my lord, I will skip those documents, my lord.
Yes.
I have the PhD guide. On my guidance, my 3 got doctorate. By now, I think there are more. But the respondent 12 has got. I've also annexed their names who got the doctor under my guidance. 53, 54. Then were my page 56. And this having complete social examination 60 absences. So he was awarded doctorate of philosophy on my lord 20th February 2004, certificate issued in 2006. Then page 58 Annex G. I request for furnishing the copy of the approval of proceeding of selection committee held on 11/4/2022. There is model 19/4/2022. Then comes the respondent's affidavit. Respondent R4. This ability is important. Your lordship, here's annex D, C, D, and E. Individual marking statement of the members of the selection committee. Page, my lord. His annex is B, C, and D.
Of the
B,
counter.
page 77 of the counter of R4. Page 77 onwards. No, no, this is a. Think of. My name is Dr. Ranjit Sharma, serial number 5. In a minor second administrative experience, third column, I have been given 8 marks and R12 also 8 marks. Now page 29, minor, the director's order how to allot marks is there. So he has got less administrative experience and 8 years. I have got 13 years. I should get full marks of 10. 10 is the highest marks. He has got 5 years less than me. He has been also given 8 marks. Only 8 years. Because as per the page 29, the marking pattern of the department, column 3, page 29, administration. 1 point for each year of administrative experience of vice principal, principal, in charge, head of the department, other respondents, administrative post, maximum 10 marks. 1 point each. So maximum 10 marks. So I got 13 years, I should get the maximum of 10 marks. He has 8 years, he should get 8 marks. As per this is objective, my lord, not subjective. Am I clear, my lord?
Yes. He has 8, you should get.
My lord?
You should get 10.
10, because I have 13 years, my lord. 1 year of 1 marks for each year. I've got 13 years, 5 months or something. I've already said in my video. And he has got 8 years, 4 months. So we are given both 8. Totally biased marking. Then my lord comes 4th column, B. Mode of expression of clarity of voices involved on the subject. Here he has been given, because I am the already principal, I have got about 27 years of experience. Sorry, 23 years of experience. He has been given 7 marks. I have given 5. Then Lord Sultan come to 5th column. Ability to plan institutional program. Since I am the principal for last 3 years, I have been given 4 marks. He has also given 4 marks. As head of the department, RQ coordinator, PhD guide, then my principal for 3 years. I am also given 4 marks, and he was not never the principal of the college earlier. He was not the PhD guide, nor IQ coordinator. He has also given 4 marks. So, my lord, here they have made the difference. Then next page also can come. Another member, this is one member. Again column 3. Same, 8, 8. Because the unanimity mind, man. That this man should be given predetermined mind. Then column 4. I am given 6. He is given 7. Column 5. Institutional ability to plan institutional programs. I have raised the college to autonomous college, now university level. I have been given 6. He has been given 7. Unless there is biasness, my lord, lots will certainly not go into the marking of the candidate because it is the discussion selection committee. But where biasness is there, apparently on the basis of the marking system given by the director, when there is violation, then a lot will certainly interfere. Then my lord, C column. My lord, that is ability to analyze and discuss research subject. He has got no research subject. He has got no research experience to guide anybody. He has been given, my lord, 4. I am given only 3. 2. He has been given 3. That was, my lord, in every individual marking.
We'll continue at 2.
Wait 2
1 hour more.
Lordship, as per Lordship's convenience, Lordship. My just only difficulty is, Lordship, the matter which was my senior was supposed to be there in Supreme Court that got adjourned. So likely the matter is again getting fixed after Holy vacation. And that matter pertains to Constitution Bench of Assam Accord case. So
Holy vacation is 10th, my lord. Before that, what should be fixed?
March. In case there is any difficulty on 28th, Lordship will accommodate. Otherwise,
we can give a longer date.
Yes, 28.
Some allergy is coming out.
No problem.
28, my lord.
No, the longer date, the besides.
Let it be on 28, my lord. If there is a difficulty, then yes.
You have some problem?
No.
There are so many cases.
I have also so many cases, but anyway.
And the Lordship will keep it on 28 in case I have some difficulty.
R.P. Sharma, the senior counsel, assisted by me.
By the D. Dole and Mr. S.K. Boysa.
Also heard. Who is the government?
তার নাম তো কি আসলে? Upamanyu. U Upamanyu.
Standing counsel. Higher
W.
She you are appearing?
Lordship, 3. I am appearing for 3.
MS?
3 and 5 to 11.
Item 3, 3 and 5 to 11. And Mr. K.
I am
Sharma,
respondent number 4, my lord.
senior
Governing body.
assisted by Mr. DJ Das. Is the method or? Okay, then we'll have it on 28.
28, my lord. He says, my lord, actually, I was ideally asking for another date.
There's some urgency, that's why just today. Let me on 28, my lord, we will adjust. Illustrious part heard, my lord. Part heard, what angle?
Yes, part.
Part heard, yes. All right, my lord.
Please, your lordship.
Yes, please.
Lordship, I'm instructed to appear for respondent number 4.
Who is for?
Subject expert, my lord. You can assume the allegation of bias has been.
You want time?
Yeah, we'll file our reply.
Counter.
Yes.
But counsel. Mr.
R. Dekar.
R. Dekar, let the council enter appearance on respond number 4 and praise for how much time?
2 weeks.
2 weeks time to file counter. Mr. P.T. Nair, let the accounting council.
Cotton University.
Appears for the Cotton University. Is the matter of 2 weeks. Eight. Is the matter on?
What's up?
On the last occasion, my lord, the other side took adjournment for replying to my submissions. Part heard, my lord.
This is regarding that
This experience marks for experience to the contextual teachers.
Here we have filed our affidavit, my lord.
when? Yeah, you filed your affidavit.
My lord, in WPC 526, my lord, of 2022, my lord, on 18th of August 2022. Here we have filed our affidavit. Our stand is that, my lord, kindly see para 5 of our affidavit, my lord.
Master. It's like 2 minutes. Mr. Sharma, Learner Standing Council, appears for respondent, Learner Standing Council, Secondary Education, appears for respondents 1, 2, and 3.
Yes.
And Mr.
D.K. Roy,
D.K. Roy, Learner Standing Council, Assam Secondary Education Council,
Higher Secondary Education Council.
Assam Higher Secondary Education Council. No, that's the stop. Mr. So-and-so enters appearance on behalf of the Assam Assam Higher Secondary Education Council and prays for how much time?
My lord, at least, my lord, 2 weeks, my lord.
Prays for 2 weeks time to file contract. Is the matter of 2 weeks in the admission form.
Deeply obliged.
Yeah, please, your lordship. My lordship, I've informed Mr. R. Barpujari. He's amidst the hearing. He's just coming. Your lordship. R. Barpujari. He's amidst the hearing. He's coming. I've informed him. Lordship.
This is the last matter.
Earlier occasions also, the time was taken by Mr. Barpujari.
The petitioner is aggrieved by list of similarly situated graduate teachers who have been given regular pay scale. Now I'm getting a fixed pay, but not a regular pay scale.
Well, in this matter, process is going on government level, my lord, and moreover, my lord, financial approval also required, my lord. So, my lord, 4 weeks may be granted so that I can apprise the court. The finally that something is going on.
You are considering the petitioner's case.
Yes, my lord. Rekha Vora.
The time was taken in March 2022 for filing an affidavit. So the process
So-
might be expedited.
So, this process is going on in government level, my lord.
How long will it take from March to March? 1 year, 12 months?
The
So,
cabinet has
fin-
already given approval.
Financial approval also required, my lord. At least 3 weeks, my lord.
Okay. You are Mr.
A.W. Aman.
But Mr. A.W. Aman, then the counsel for the petitioner. Mr.
Yu
Yu
Sharma.
Sharma, then the standing counsel.
For
It's
secondary
around-
education
it's
department.
around 3 weeks time to file contract. List the matter again on, give a date of 3 weeks.
Deeply obliged.
Deeply obliged. আপোনালোকৰ এইটো হেৰি হৈছে
Proposal was to submit on the finance part, my lord, on 3-4 occasions, my lord, the matter has been.
When is your senior coming back?
My lord, he'll be there on Monday. My lord, probably your lordship has heard at some length on his part. So his part is completed. And thereafter, my lord, the department, veteran department has also submitted before my lord.
Who was applying for the Barbujari?
That junior.
Our Barbujari is in court number 18, some argument is going on, and Shirish Mehta was there, my lord. Shirish Mehta is there going on. So, A. Solia will come here. A. Solia will come?
Has to appear and finish the cycle.
Lordship, here Mr. R. Pujari appears, my lords. He's been on legs the entire day, my lords. There's a new pension, old pension scheme matter going on, my lords. Lordship, if today is the last date from what I've been told for that matter, my lords, and he's been stuck on it, my lords. Lordship was short like any other date, my lords. Mr. R. Pujari will be a Lordship. I know he's been a.
This case has been.
Yes, Lordship, I'm aware.
I don't know how many days.
Yes,
my lord.
More than 3 months, my lord, that has passed.
Lordship, but
5/11, 15/11 was the last date where he appeared.
On the last date also, my lord.
17/11 order.
Well, on the last date also, my lord. Last date, the matter did not reach, I think, my lords, and then this matter was fixed
No,
today.
it reached.
Oh, Lordship,
Barbujari was not there.
Yes, my lords. Lordship, he's on legs, my lord. That is the only issue, my lords. Any date, my lords.
But Mr. Betala.
Yes,
Learned counsel for the petition. On request made on behalf of Mr. R. Barbujari, standing counsel, finance department.
Lordship.
When?
Lordship, tomorrow at 2, my lord, if that is convenient to my brother, my lord,
tomorrow,
because my lord, only the issue is that his part he'll hardly take my lord 15 to 20 minutes, not more than that. If I could
Tomorrow, I
presuppose,
think
my
it
lord.
will be difficult, no?
But then my lord can reserve it after that, my lord, if I may submit. my lord, that
Any
part-
day, your lordship, any Monday, Tuesday, your lordship, any day.
Monday we'll have it.
Lordship,
Monday
lordship.
on 27th.
Lordship.
My lord, as a final opportunity.
Lordship, lordship.
Make sure he comes.
Lordship,
Yes, my lord,
lordship,
as a
lordship.
final opportunity.
So he's been on legs the entire day, lordship. Yeah.